Thank you very much, Chairman, and good afternoon, everybody. Great pleasure to be back in Dubrovnik. I'm beginning to feel very local here. I know my way about. I can't say that about many places in the world. But again, the organising committee, thank you for your confidence and inviting me back. Always a pleasure academically and also socially. And I have to say that over the years, I've built up quite a regiment of friends here. So I look forward to much socializing in the next 3 or 4 days. And sadly, I have to return on Sunday. The garden demands that I can only be away 4 or 5 days this time of year. Otherwise, it's a very long round. Also, I'd like to say that I appreciate very much the earlier work said about Professor William Ketley, which I will endorse. Great friend of mine, great loss to my life, very colourful, very imaginative, very interesting, very entertaining. What we call a character, right? Especially Welsh. Welsh has a word for character, and sadly, the world is losing that kind of person. Not only have we lost William Ketley, we've lost many interesting characters. I think most of the professors who taught me or tried to teach me law would not be acceptable in today's universities and have lost their jobs very easily. Also, I've done something which was very improper. I have neglected to read the program before preparing my paper. So I've been given my title, which I took, and hopefully I'm applying myself religiously to it. But then I see the program and I know that my co-speakers, particularly one of them, is taking on the same field, but in a more specific way, and the other again to a degree, but generally. But I therefore will adjust my talk a little and make sure that I don't step on their shoes and leave the field clear for them to discuss their particular subject. Now, there's going to be a little bit of as it were, overhanging material here, but I'm going to discuss. Okay, I will set that.
It's in recordings.
Oh, I see. Okay. Igor, is this part of the contract? Yeah. And my manager covered the fees on this. I mean, this is going worldwide, I think. Okay. Okay.
But I did it.
You did it?
Yeah.
Sorry.
Okay. I actually,
Sorry.
I'm here to talk about law, but I think there must be many more amusing things to speak about. But talking about this, I was called into the doctor the other day. I had a blood test, and so there's something they wanted to follow up. It's okay. I don't think I'm dying tomorrow. But and unbeknown to me, I was with the doctor for about 30 minutes. I had an examination, confidential check. And when I got home, my wife and daughter knew everything about the interview and the examination. They could tell me the diagnosis and what had been proposed. And I was flabbergasted. I thought, how? Apparently, accidentally, I had switched my mobile on. And I'm not a technician, so I can't tell you which switch it was or what the device was. But they heard every word of that interview. Isn't that remarkable? I find it remarkable, but also funny. Because it tells you the potential, doesn't it? Anyway, I will talk specifically about these rules as they apply in UK law. Before I start there, let's remind ourselves of the international regime. My previous speakers have been in this field. Okay, so that's what we have. International harmonization is meant to achieve international harmonization. What we have done is move from a certain untidiness between national laws to an equal untidiness between international conventions. So now we have a conflict of international convention problems. And I suppose what hasn't been positioned so far is in this, the position of the receiver of the cargo is important as the shipper. So the question is, how do we get the basis of an international sale was explained to us a little earlier. So how do we get to protect the position of receiver? Right? And that obviously is a significant part of this legal system. It is only the Rotterdam rules which address that subject. Because the Rotterdam rules, and I'm not going to discuss it, it is more of an international code than a system that's regulating a contract. But the Rotterdam rules does it, but if I may say so in honesty and with caution, in a grossly inadequate way, and it's one of the least satisfactory aspects. So that's the general position. If we move on to the UK, what do we have? Well, the UK is a head Bisbee country. Right, so we've got COGSA 97, everybody's COGSA Carriage of Goods by Sea Act 71, given us the Hague rules, which repealed the earlier act dealing with the Hague rules, right? And subsequently, as has been mentioned, we've got the SDR convention, and that's been explained to us. In the UK, the third party position, especially and transport documents and primarily concerned with bills of lading here, right? COGSA 1992 affects that, which is quite a technical piece of legislation. Now, the structure of the Hague Bisbee rules, again, I'm not going to go into the details, but the Hague Bisbee rules essentially is there to regulate the contract between the shipper and the carrier. Straightforward contract for the carriage of cargo by sea. So it defines for us, the scope. When do the Hague rules apply? It is concerned with bills of lading only. Defines the duties and the responsibilities of carriers, their exclusions, the defences, the rights of limitation, the duties of shippers, the extent to which the contract may be varied, and prescribes formalities with regard to time limits and also limitation of liability, which will be discussed. Right. So it does the things that you would expect to be done with regard to a contract for the carriage of goods by sea. Now, the Bisbee Amendments modifies certain aspects. Doesn't rewrite the Hague rules. It just modifies certain aspects. So it renders the bill of lading conclusive evidence in the hands of a third party. The time limit is modified a little. And I'm sure we'll hear the word whatsoever is introduced. And what does whatsoever mean? All this big commercial litigation is often about little English words and what they mean. The drafting is very important. It introduces time limits and for indemnity claims, new limitation of liability, as is being indicated by a previous speaker, and the introduction of the container has revolutionized the carriage of cargo by sea. So the container, to a degree, has been accommodated. It's made sure that the defences, the limitations apply, whether you sue the carrier in contract or tort. And often the attempt is made to avoid the inconveniences of the contract by suing in tort. Well, it doesn't work like that anymore in common law. But more significantly, and again, as an earlier speaker mentioned, it makes the same point if you sue an agent or the servant of a carrier as distinct from an independent contractor. And that's another aspect of English law. You'll find us, I'm a Welshman, but I'm talking about English law. Talking about, we're talking about employees. agents, independent contractors. What we don't want you people to say, how do you distinguish? It's very difficult. It's very difficult. And the other big aspect of Hague's rules, again, as we say, it extends on the application. Now, very often you'll see there's a lot of writing in my PowerPoints, but I will just make a few points. So you can take the PowerPoints away and have a more comfortable read through it. But the Hague Act gives the Hague-Bisbee rules a force of law. Now, that is in itself a very easy thing to say, but it has its implications. So far as English law is concerned, when you are within the Hague-Bisbee rules, your contract is governed by law, not the consent of the parties or some kind of mutual consent. And that has implications, because when you look worldwide, the Hague rules, the Hague-Bisbee rules can also be operated contractually. And numerically, that is more often the case. But the big difference is, if it operates by law, you can only modify the contract to the extent that the contract itself permits modification. Whereas if you're applying it contractually, you can rip up these duties and rights and do it your way. But most people don't do that. Right? So it is quite a significant thing. Also, the UK Act applies to UK shipping. So if you are trading between England and Scotland, Northern Ireland, the Act applies, notwithstanding that it's not international in the strict sense. And equally, the Act applies it to waybills, providing the waybill expressly incorporates the Hague-Bisbee rules. So one of the limitations of the old system, and still is to a degree, that it is tied to bills of lading. And we've got a massive other kind of transport documents out there. And those other documents are less troublesome than bills of lading. Okay, so this is just giving you a little background to what the position in UK is. And the Coxon 97 Act is a UK piece of legislation. Right? So we're increasingly a broken constitution with Scotland, Wales, England, Northern Ireland, and possibly we did leave the United States float away. Yes, and by the way, Michael gave us some customary excellent lecture on the background to wars, and that background does explain such a lot of the presence and attitudes towards it. Now, what I want to now talk about is, I've already said, and you will see it, the evidence will probably be identifying cases. Right? The big litigation in London today about Hague-Bisbee rules is all about the wording. And I've said it before, lawyers should look more into dictionaries and books dealing with the language and how language evolves and is to be responded to than the law stuff. The detail, small, the devil is in the small print, isn't it? So, the question is, if you've got an English commercial court, how does it look at a dispute relating to the Hague or the Hague-Bisbee rules? And what I say now applies to both. Applies to both. Okay, sir. So let's see what it is. The courts always draw a distinction between a national issue and an international issue. So the Hague-Bisbee is international. And therefore, the ground rules change. You don't look at it as if it was a domestic state. It's international, it's governed by international public policy, and therefore there are other jurisdictions which are interested or may even contribute to the debate. Second point to make, it goes to the Vienna Convention law treaties. because that deals with the international law, treaties, conventions, and agreements. So it takes its ground rules not from national law, but from an international law dealing with treaties generally. And it says, and this will be my first quote, a treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty, in their context, and in the light of its object and purpose. Standard. So essentially, the words of the treaty are primary. You're going to look at the words and you are going to interpret them, but in context. You know, all language, and particularly in the English language, can be controlled by the context and how you control the word. Now, the query is, that's the fundamental principle, but with the courts always comply with it. And then it goes on to say, and again, relevant to our, it recognizes that there may be recourse to what it calls supplementary material. And the supplementary material may be used, and here I go, you see it again, right? Preparatory, to include preparatory work of the treaty and the circumstances of its conclusion in order to confirm meaning. So you can refer to the supplementary in order to confirm the meaning, or to determine the meaning, or to resolve what is ambiguous or obscure, or which leads to a result which is manifestly absurd or unreasonable. So the convention says, firstly, the words, and then if there are such reservations as I've just indicated, if you are left still in some doubt and uncertainty, and that is justified, or if you don't like the outcome, you can then refer to preparatory material, preparatory to the treaty. And of course, a key word then is, what is preparatory material? Well, that takes us into the context of a travaux préparatoire, right? Something that has been prepared preceding the emergence of a particular international document or treaty or whatever, and which seeks to explain it. Now, increasingly, a lot of organizations produce such travaux préparatoires. They are conscious of this fact. And you get into, people like Untied and Uncitral, and to a degree also for CNI, and certainly national bodies will do that in the hope that if there is a problem, the court will go to the travaux préparatoires. But note, the notion of the travaux préparatoire is constrained. You can't do it as part of your natural process. You can only do it having done it, and then you consider some kind of reservation or doubt or dispute. Now, what amounts to travaux préparatoire? It must be something which explains the document. And therefore, in a sense, it's got to be written or provided by somebody who has been part of the process of explanation. Of course, you can have national variations in these understandings. And I'm just giving you the English view. So, academics frequently think, court should be able to read this article, and it should read it because it will help the court to understand. Is an article written by an academic part of the travaux préparatoire? He's refers more. But if the academic has been part of the process of creating, if the academic was on the law reform body or some kind of committee, so they had internal sights and understandings, then, I just edited a book on the Beijing Convention. We had 6 contributors, and we also had the president of the CMI provide a contribution. myself and my colleagues would be terribly disappointed in my observation that they are not part of the travel opera. But Anne Fenwick is. Her essay will be because she, as president, was also part of the process throughout the years of producing the convention. Now, even a travel preparatoire, let me just see what I had to say next. Even a travel preparatoire is not necessarily determinate. Still, the court has a job. And the English courts have said, we will only treat travel preparatoire as determinate, as concluding our opinion. Now, if it applies itself expressly and clearly and unambiguously on the point before us. And they conjured that up by saying, if the travel preparatoire hits the bullseye, we will follow it. And what my co-speakers will be talking about a little later are all cases, well, to the extent cases in the English court, where the travel preparatoire of the Hague and Hague-Bisbee rules have been very strongly before the courts, and they've made these following points. Very quickly on this first point, the initial Hague rules, the official language is French. It's not the case in Hague. So exciting. And then the question, if you have an official language attached to a treaty or a convention, then the convention could be looked at in that language. Interesting thing about the Hague rules is, as I might have it on the PowerPoint, it was formulated in English, then translated into French. And then subsequently, I think we considered in English and ultimately appeared officially in the French language, which was, of course, the language of international diplomacy in the early part of the 20th century. So I passed that by very, very clear. To reproduce the point I've made here, international uniformity, the English Commercial Court weighs on this. If you've got an issue with regard to the Hague-Bisbee rules, very relevant if you can dig up some overseas case law, which is relevant, attached to the same convention. It is citable and it can be of influence. So the court is concerned that has an international position outside the UK been agreed upon this? Is it clear, to the extent that there is evidence, that all the other state parties to the Hague-Bisbee rules have come to a view on a particular subject? And if that is the case, 99% of 100, the English court will follow that decision in the interests of international uniformity. Because that is what you need. There's no point having an international instrument, the object of which is uniformity, which is then construed differently by every state party. And as I emphasize in my PowerPoints, this is particularly important with regard to our subject. And a few people have mentioned the Muncaster Castle. And it is an excellent example of the point I'm making, and the point has been made. Where the question was, I mean, in a phrase, was the duty to provide a seaworthy ship or to exercise due care? And with regard to the obligation, was it delegable or non-delegable? And the court, where did the court? Went to the courts of the United States, went to the courts of Canada, went to the courts of Australia, New Zealand, looked at the decision and found uniformity. They were all coming up in favour of a non-delegable duty. And therefore, although that holding was contrary to the established position in English law, they held it to be the case with regard to the Hague rules. So the English courts, commercial courts, are now obsessed with construction contracts. Every judgment begins with a couple of pages, the judge telling us how precisely they have gone about this task. And somehow I create the courage to say, I have read all the case law on this topic, and I have read it and understood it, and I do apply it. But brackets, please do not cite me. And it's, you know, it's the same with regard to the Hague Dispute rules. That there we are. Okay. I've already lost track of time. So if you just anyway, just in case I'm okay. Just throw something at me if my time is up. So, okay, so that's the position. The UK is a busy country. We have a lot of litigation. And probably, you know, a lot of countries, I suspect, may be looking at decisions that arrived at with regard to pay disputes. And certainly our commercial court does. Now, in the recent case law, there have been a lot of points of interest, but some of them are deeply principled, and others are very often, you know, about the meaning of words, and very often they're little on the surface quite inconsequential adverbs or adjectives. You know, they're qualifying words, and man, you know, they can. Well, the truth is millions. You know, it's a lot of money. Now, the Volkov, and I think it's going to be touched on by one of my co-speakers. So, shall I just say very briefly? The Volkov was a surprise because it said something that nobody had thought for decades upon decades. And it took one of the most brilliant judges of our times. Really smart. Okay. Because everything about carriage of goods by sea was contract. And he said, well, no, it's really bailment. It's bailment on terms. So he went back, and bailment, for those of you who are not familiar, is a system of law founded on possession. A contract is all about agreement. And bailment came before contract. So in the 18th century, bailment was big. And I think somebody mentioned a little earlier, I think it might have been Michael, about essentially what we call common carriers, who were a form of bailee in the 19th century, and our early law of carriage started there. So when you looked at it, he said, it's because you are giving cargo to a carrier. So the carrier has possession with consent, and of course there is a contract about it, but that contract doesn't necessarily displace bailment. It can qualify it, and ultimately it could experience it. But in the absence of that, and so he analysed carriage in these terms, and the fundamental principles of bailment were the bailee is not an insurer. The duty is to exercise care, and the burden of proof is on the bailee. The bailee is to show that he acted with care. So now, as a rules agreed with Lord Sumption, and they said yes, and Sumption himself said there are exceptions, and we've been looking at seaworthiness, and there's another in the exclusions, which represent exceptions, where the Hague Dispute rules actually deals with the question of burden of proof. But other than that, it doesn't deal with evidentiary or procedural matters whatsoever. And he said, well, now, as editor of a journal at the time, it was great because I was receiving articles on this right in the centre. Everybody disagreed. But the more you think about it, you know, the more you agree, and also the more inconsequential it becomes. Because all he's saying is that if you've got a claim against the carrier for damage or loss, all you have to do is to say, there's my goods, here's the damage loss. Carrier now has to prove that he exercised care. Well, isn't that the way ordinary litigation works? I mean, all the shipper has to do is to say, leave bill of lading. Over to you, Mr. Carrier. And precisely, that's how they worked it. So we're dealing with principles of bailment as distinct from contract law, but contract law can supersede it. And of course, generally, and I think I've looked upon this subject in the last X years totally in terms of contract. So, contract terms. Okay. Oh, there we are. I've got time. Now I think we have, well, my colleague is dealing with this, but I give you the cause just to confirm my view that these little words cost a lot of money. So the time limit in the Hague and the Hague dispute rules is carrier shall be discharged from all liability unless it is brought within 1 year of the delivery of the goods to the date when they should have been delivered. And then the Bisbee formula added the words whatsoever. I think that's right. So we had a distinction between all liability and a distinction with all liability whatsoever. Now, if I've written that in my sixth form to my English teacher, he or she would have drawn the line through whatsoever as being surplusage. Redundant means nothing. If all liability cannot be qualified, it means all liability. Whatsoever doesn't add anything except. So it's appeared in the Bisbee Amendment. Does it indicate some kind of change? And one of the things I haven't said, and I'm sure one of the earlier speakers must have said, that basically the Hague Bisbee rules cover the commercial position from loading to discharge. So pre-loading, post-discharge, not covered. But now we have goods to order that should have a year of delivery of the goods when they should be delivered. So we have the concept of delivery coming in. And the question before the court was whether this timeline, the time limit, applied to misdelivery goods. I'm going to leave that to my speaker. Right? Is that I'll leave that to the speaker to my next speaker to address. And then that was a joint case, and then we have this the Tolko lineage, which is a very interesting case. Again, you see it there, and this is the limitation of liability with regard to weight. And you see it says, and you can read it for yourselves, and then the liable for any loss or damage to or in connection with the goods. So, the package limitation or the weight limitation, right? Limitation of liability applies to any loss or damage to or in connection with the goods. Now, the question here was, did these words apply to economic loss? On the face of it, nothing is said about economic loss. But if you think about it, goods can be damaged. I see. And obviously there's compensation for the damage. But the damaged goods can then have a commercial discount. So the buyer of the goods is not only receiving and being prejudiced by the damage, but he's lost part of his market. Question is, does that claim come in? It only went to the judge's first instance, and again, I suspect, and it held, yes, it was held that damage includes economic damage. Oh, okay, so where do we go? That's the talk on lineage. Okay, that's that. So, now, I'll express a personal opinion. Now, the question with the English Commercial Court is that it's become an international policy body, not a commercial law being asked to interpret commercial provisions, right? It's more or less affected by what ought to be the position, or what position people would support without it necessarily being possible to arrive at that decision through the construction of the words involved. So in a sense, it's almost doing for the Hague rules or the Hague Bisbee rules, but the CMI did through the Bisbee Amendment. And a lot of people said for a very long time, there's call for another amendment. So there's a risk. It's being, and because it's looking at the travel preparatoire and the discussions that are reported there, it's taking some of that evidence as justification. So you're resulting in some very strange interpretation. Of course, that's a personal view. A lot of people might possibly see things to the contrary. Okay, but and remember, the first starting point is the meaning of the primary words. Everything else is a qualification. The criticism is being leveled at our commercial court by virtue of the fact that it's forgetting the importance of the first line. And it's looking for ambiguities possibly and uncertainties, knowing that the way it wishes to go possibly takes the support of international bodies and possibly the industry. And some of these interpretations that will benefit shipper and some to benefit of the carrier. There is inherent in all of this a big debate about what's the distinction between discharge and delivery. Well, any person of commerce or a commercial buyer who doesn't know the distinction shouldn't be in the satellite. Discharge is when the ship is unloaded. Delivery is when it's transferred to the person with the right to delivery. So discharge comes and precedes delivery generally. They might be running in parallel. And of course, the delivery may be very quick after discharge, or it could be quite extended. And the question is asked, what happens between discharge and delivery? And what the court seems to be suggesting is that the Hague Bisbee rules creeps a little into delivery, just a little. And yet, the Hague rules tells us time and time again, this is a code between this loading and discharge. It couldn't be plainer. And really, to have delivery in what is a time limitation doesn't offend the principle of time, because I can really see the justification. What you're doing now is defining the passage of time. Nothing to do with the contract, to do with the claim after. And we've heard a very recent case, just before our commercial court, where precisely this distinction, where after discharge, goods were damaged. Was the carrier liable? Here in the first instance, not post. And they tried, and it was interesting, they tried to seal the carrier in tort, knowing that there might be a problem with contract. So it's becoming a grey area, and it can, and sometimes, you know, ship owners will give you discharge and know you say 14 days to receive delivery when they're implicitly accepting responsibility cargo for that period of time. But again, that's outside the Hague Bisbee rules. That's dealt with by all the contract. And the Hague Bisbee rules allows you to enter into these additional agreements and what have you. But I think my colleagues might have a much more to say about all those things, and they may disagree with me. And I'm not sure I agree with myself after that. But okay, I finish with this. We haven't talked about one of the big problems, and the Rotterdam rules tries to solve this explicitly. You know, who's the camp? Who are we going to sleep with? Because, you know, very often we have a ship We have a demand charter, we have time charters, we have voyage charters, we have sub-voyage charters, and we have bills of lading. And somebody's paying against the bill of lading, cargo, it's a very complex area. So you've got to unravel all these relationships and come up with contractual ties. I mean, one of the real problems with the Hague rules in practice is when they're incorporated in charter. They're not meant for charter. And they expressly say, no, we're not in a charter party. And then you have a nice charter party, it's already run for 24 pages. And then there's a clause there incorporating the Hague Institution. And nobody thought about how that relates to the charter party. So you can have, the Hague Bisbee rules saying seaworthiness is due care and attention essentially, and then the charter party says seaworthiness is absolute. So we have clauses which are fighting each other differently. Somebody's in the office said throw the Hague Bisbee. And so you get this total muddle. And of course, the Hague Bisbee rules can apply outside the province of the law of international law, because anybody in this world can just pick them up and say, incorporate them. And they then exist as contractual terms. And they're very, very prevalent. And we can end up with also very rare conflict of convention disputes. So you could have a situation which might fall within two or more conventions. And that's more likely to happen between Hague Bisbee and the Hamburg rules than any other. So you can suddenly have a situation which might turn on which jurisdiction you actually determine the dispute by reference to, and which jurisdiction, which system of law that jurisdiction adopts. So hopefully, ladies and gentlemen, that wasn't too hurried and too discursive. But under English law, our commercial court deals a lot with the Hague Bisbee rules, charter parties ad nauseum, and so forth. So there's a lot of law emerging, and I think there's a lot of very interesting case law emerging. And also in the background, there's this question: what is the function of a commercial court? Is it when it's getting itself involved in what might be called contentious, debated areas of policy where there are differences of opinion. And when we come to the travel preparatoire, I think organization is like UNCTAD, excellent, and because they specifically prepare travel preparedness. I mean, the book I've been involved on, the Beijing Convention, they have produced a perfect document going through it all. Very clear, very organized, very structured, not contentious. And I know, like with regard to CMI, and I know there are people from the CMI here, I'm also a royal member, but I think that the CMI could really think about this. Because really just to record the discursive debate that takes place in the meetings, and like over time, where things are changing, I'm a member of the committee, I mean, committee changes every time we meet. Where's the continuity? I mean, it's and also the idea of applying yourself to preparing the travel for travel trust. It's a very important function. As you know in the picture, it can be even more important than the primary document itself. So you need to be clear, organized, and coherent. Anyway, thank you for your attention.